Now, while we are awaiting the verdict in the Karen Reed trial out of Massachusetts, we're also keeping an eye on the latest on the Alec Baldwin case. Jury selection is set to begin July 9th for the movie producer and actor of that Rust movie. Baldwin standing trial for involuntary manslaughter in the fatal on-set shooting of Rust cinematographer Halyna Hutchins. She was shot and killed when the Baldwin gun he was holding fired a live round during rehearsals in Santa Fe, New Mexico. Remember, armorer Hannah Gutierrez-Reed was found guilty of the same charge, involuntary manslaughter, back in March of this year. She was sentenced to the max 18 months in prison. This week, attorneys were present for a number of hearings ahead of trial, with the defense trying to get the manslaughter charge dismissed against Baldwin. The defense asking the New Mexico judge to do that because the gun used in the rehearsals, the one that actually fired the bullet, was damaged during the investigation of the case. Let's take a listen to all that right now.
We think that bad faith is one of the keys here, because if you agree on bad faith here, this is pretty straightforward. As I said, we read New Mexico law to mean as if you have bad faith, and as long as the gun is determinative of guilt, which I don't think can be disputed insofar as the state's legal theory depends on whether he pulled the trigger, then we're entitled to relief. That's how we read Chouinard. And again, even if it's a sliding scale, it's going to be pretty likely we're entitled to relief if we establish bad faith. The second thing is under Youngblood, again, you only need potentially useful, which just means indeterminate, and bad faith. So again, if we show bad faith, I think we're almost certainly entitled to relief at that point. So let's talk about bad faith. So really important, Your Honor, bad faith does not mean maliciousness in this context. It does not mean Ms. Morrissey and company were out to imprison an innocent person or anything like that. It doesn't mean an ethical violation. What it does mean is that, and this is right from Youngblood, U.S. Supreme Court, the police themselves, by their conduct, indicated that the evidence could form a basis for exonerating the defendant before they destroyed it. So it's basically looking at, well, did the police think of this as potentially exculpatory evidence and then just went ahead and destroyed it? And this is the other quote from Youngblood, and it's cited in a lot of the cases in this area. The presence or absence of bad faith by the police for purposes of the Due Process Clause must necessarily turn on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. So no one's accusing anybody of ethical misconduct on this one. That's at least not necessary for the legal test. What it means is that they had an awareness that this was potentially exculpatory. And instead of stopping and saying, well, what do we need to do here? Do we need to document this? Do we need to preserve this? They just went ahead and destroyed it.
Okay, there's the defense argument. Now let's listen to what the prosecution, this is Erlinda Johnson, what do they have to say regarding this defense motion?
What's important there is that Mr. Haig in that report did not say there were modifications to this gun. What he said, there were irregular off-axis diagonal tool marks of an unknown origin. It seems unlikely, although it cannot be excluded, that these tool marks were made by the FBI's testing. So he doesn't say the FBI testing didn't create these. He clarifies that after he has an opportunity to speak and interview Mr. Ziegler about how he conducted that test. That does not equate, Your Honor, to bad faith at all whatsoever. That's a red herring that the defense is bringing before this court. The bottom line is that under Youngblood, under Trombetta, they fail. Under Youngblood, they fail. They cannot demonstrate bad faith because what is really important here is, what did law enforcement know? Law enforcement knew that they received no requests from Mr. Baldwin, from his attorneys. Hey, can we look at this gun? There may have been something mechanically wrong with this gun. There was modification to this gun, was a fortuitous defense that the defense developed after the gun was damaged, or not the gun, but the internal components of the gun were damaged by the FBI testing. You have a witness who in a pretrial interview stated that he saw Mr. Baldwin pull the trigger, that's Zach Sneesby. Mr. Baldwin's own statements that the gun was working fine.
So the court has yet to rule on that particular motion. There were a number of other motions the court has ruled on. There was a general motion for denial of the indictment, a dismissal of the indictment, denied. Immunity for Hannah Gutierrez-Reed, which we could talk about, that also was denied. And a motion to exclude witnesses prior to their testimony, denied. So again, this is the one we thought would be denied, decided today. Maybe it will be denied, but so far nothing from the court. So still with me are trial attorneys Lateef Gray and Catherine Lizardo. So Lateef, let me ask you about this gun thing. If in fact the prosecution in testing and I guess examining this gun damaged it to the point that the defense can't really rebut what they allegedly found, that sounds pretty damaging for the defense.
Well, it is pretty damaging for the defense because they're not allowed to test this weapon at this point, and they're not allowed to explore the exculpatory value of the weapon at this point. And if the state and its prosecution team destroyed this piece of evidence, then the case might get dismissed. Now, judges are usually reluctant to just simply dismiss cases because they want juries to decide the cases on the merits and the facts. But if this was a big enough destruction, then the judge may be forced with no other option but to dismiss the case.
Yeah, and so I agree with you. I don't think the case is going away, but I do think that there is something to talk about at trial, Catherine. I mean, you can certainly talk about the custody of this evidence, the chain of that custody, whether it was broken or not, and whatever experimentation was done and how it damaged my case, the defendant.
Indeed, the judge said that even though she's not ruling yet, that the parties must still continue preparing for trial. So there's an indication that she will deny this motion like the other motions she's ruled on so far. And what I see here is, yes, the gun, the defense is prejudiced because they can't test the gun. I agree. I mean, someone died because of the gun. So the gun is very important. That's an understatement here. The question, though, in my mind is the issue about the gun malfunctioning or the fact that there was a live bullet in the gun in a movie set. That's what they were arguing before, especially with Hannah Gutierrez, the armorer, that there should not be any live bullet in the movie set whatsoever, but somehow it ended up in that gun that Alec Baldwin ended up pulling the trigger for the shoot. So the defense now is raising the defense that there's a mechanical failure, but even if there was a mechanical failure in the gun, there should not have been a live bullet to begin with.
Yeah, I mean, don't get me started on that whole issue. I mean, why the heck are there live bullets anywhere on any movie set? So, Lateef, what do you expect from this trial and the celebrity factor? You know, Alec Baldwin's going to be sitting right there, charming the jury.
It's going to be a tough road to hoe for the prosecution as it relates to Alec Baldwin. They're going to have to somehow prove that when he fired this gun, he knew that there was a chance that it was a live bullet in it. And that's going to be hard to prove, given that I don't think it was his job to handle this gun prior to using it as a prop. So it's going to be a tough road to hoe for the prosecution. I think the case was brought against him because it's such a high-profile case, and they want to get as much meat off the bone as they can. So tough case for the prosecutor.
Yeah, I think it is going to be very interesting. There's a certain, weird celebrity vibe, but also a thought process that is interesting, which is, hey, man, that's just my job is just to hold the gun, and anything that happens before, it's not mine. It's not my responsibility. I think it's a horrible position, but you've heard it. Alec Baldwin did that interview in which he said, no, I never pulled the trigger. Well, we'll see if the jury says yes or no to Alec Baldwin. Again, that will be beginning here on the network on the 9th of July. Stay where you are, guys. We're going to take a quick break here. We're going to pivot back to Karen Reed, back to the jury that is having some trouble, said to the court, we're deadlocked. Court said, go have some lunch, take a breath, get back to it. And we will get back to that case right after this.